What if your common law spouse dies and the real estate and other property was solely in their name? I'm Tulsa attorney James Wirth. That's the question that we received online that I'm answering here, and need to know what you would do under those circumstances. So first off, if it is a common law marriage, that means essentially that you're married. So it's no different in the legal consequences if you have a marriage certificate versus a common law marriage. The only difference is in the practical side, which is that you have to prove the existence of a common law marriage, whereas it's already pretty much proven when you've got a marriage license filed with the county that you are married. So if this happens in your case, you want to file a probate action. You want to request to be the personal representative of the estate, and in there you want to file to prove you're a common law spouse. Once you have proven in there that you're a common law spouse, you're going to be treated exactly the same as if you had a marriage license on file. So how is that treated? Well, it depends. So did your spouse have a will in place, the last will and testament that said where their property is to go? Or did they die intestate, in which case it's going to go by the rules of intestate succession. Regardless, though, the same thing happens as the initial stage, which means that it has to be determined what property is marital property and what property is his separate property. So any property that is marital property is going to go to the spouse, because that is marital property that they're entitled to their split of that. So if the real estate was just in the spouse's name, that is not the end of the inquiry. That's kind of the beginning of the inquiry. If it was purchased during the marriage, the common law marriage in this case, then that's going to be marital property. So the spouse is going to have some entitlement to that. If it was purchased prior to, then it's a little more complicated. Was it commingled in such a way that made it, that transmutated it from separate property into marital property? So sounds like it was not transferred as to deed. Was there a new mortgage put on it? Was the mortgage existing being paid from marital funds during the marriage? Were there improvements that were made to it? What changed in the characteristic of that property that may have commingled it with marital property in order to transmutate it into marital property? If it was purchased prior to the marriage and it was kept completely separate, then it's going to be separate property. Then 100% of that property is going to be distributed either pursuant to the terms of the will or through the rules of intestate succession. But if it can be shown to be marital, then it's going to be split so that the spouse gets their share before the other share is split, which means that they could get half of it for their marital share, and then they could get a fractional share of the other half, depending on what the will says or what the how it falls in with what heirs they have under the rules of intestate succession. So there could be a lot of different factors that will make a determination on what happens here regarding what's happened with the property and the character of it, and regarding what heirs they have versus whether there's a will or not a will. So a lot more information to provide for you, but I need some additional facts for that. But if you're dealing with this circumstance, it's nice to have some general information from a video, but you're definitely going to want to talk to an attorney privately and confidentially to receive actionable legal advice. To get that scheduled with an attorney at my office, you can go online to makelaweasy.com.